Welcome to Q&A practice. Let's start out with some colloquy practice. And we will start with the court. Ready? Here we go. That comes in. I think all of that goes to suffice for the purpose of establishing at least a view that Mr. Perez was dishonest in his response to the police. Now let's talk about the specific issue of whether or not the jury should hear physical abuse. If he was abusive verbally, the fact that he was also physically abusive doesn't provide a lot of additional information for the jury to use to determine whether or not Mr. Perez was dishonest in his interview. And Mr. Franks, now I'll do the same Socratic reversal, does it? I could see under 352 the court could perhaps say that statements of prior physical abuse don't add a lot to the statement that she suffered verbal abuse and was unhappy. I could see the court doing that. At this point, I'm kind of looking there. Again, this doesn't have to be my final ruling on this. We are not going to bring it up in jury selection in any event, and we can revisit it. What I'm interested in, what I said before, is looking at the cases that talk about under what circumstances courts have sustained allowing a trial court to let in the statement by decedent that he or she was afraid of someone, and those circumstances do occur, and I don't know what I'm going to have to say about those until I look that up. And if anybody wants to provide me with any of your own collective efforts at solving problems, I'll be happy to look at the product of your work rather than doing it for you, Mr. Franks. But anyway, we will move on. Yes, sir. So certainly just for my purposes, so I understand you're granting motion 4 based on what I just asked for, which is she's unhappy in her marriage and intended to live with her daughter after the divorce. Yeah, I think so. But again, I would ask that I be apprised ahead of time of the specific we are going to use, right? And the reason why it's very simple, Mr. Franks, because you are going to have the obligation to make sure that whatever, if I end up tailoring any type of testimony that you can elicit, you are going to have to tell the witness, do not say this, that, or the other thing, because we are not going to be able to have to unring bells. I don't want to have to go through, ladies and gentlemen of the jury, you heard such and such. Please disregard it. That would be my preference. I'll just say right now, I will limit it to, it's on page 487 from Sarah Richards, that Sue was getting divorced and that Sue, the victim, was set up to move to Oregon with Richards once the divorce was final, and that basically that Sue was unhappy in the marriage. That's what I'll get from Sarah Richards, and I'll get the same thing from Ms. Ryan, and that is basically it. I'm not going to get into. So let me just say, you are not asking for me to allow them to, one or both, to testify about a physical abuse or fear of the defendant. Not pending. I've got to do some research on that fear issue. You haven't researched that yet, so I brought that up to you. You never thought of it. Well, I don't think she ever said fear. She just, well, afraid of him? No, she said, I'm just tired of it. I thought somebody else said, she said that, I thought Ann Ryan said he was physically abusive and I was afraid of him, said he was abusive, but did not tell her how long the abuse had been occurring. That is her statement. No, Miss Ryan did say that Sam was very abusive to Sue, and Sue was afraid of Sam. That is what I thought you read on page 404. I see it. You not only saw it, but you read it to me. I see it. Okay, at this point, he hasn't asked for it. I'm sure if he wants me to do it, he will provide me an opportunity to review the authorities that he's going to present on that. Thank you. I am going to grant number 4, number 5. Yeah, I'm sure that I don't think I need to take judicial notice. I'm certainly going to allow you to establish, if that is the way you want to get it to the jury, you can tell them that what a joint tenancy is. However, you want to get there, right, Mr. Allen? Yes, sir. So that's granted. Basically, I can tell the court in my closing argument, basically describing what a joint tenancy is. Well, you probably want evidence. You can call Mr. Allen as a witness. He went to law school. Go ahead. So do it with judicial notice, that's fine, or we can do it by stipulation, however you want. Okay, I would be happy to do it by stipulation if Mr. Allen wouldn't mind. Don't waste my time. We are going to allow it in. Number 6, motion for the court to take judicial notice. That's basically, that just defines what a joint tenancy is, and that it ends if there's an agreement to sell it. That's not what that case says. That's not what you cited the case for. An agreement to divide the proceeds upon the sale terminates the joint tenancy, right? So whether it's sold or not, they make an agreement. True. If that's the law, okay, fine, I'll grant it. Number 7, Mr. Allen, what do you say about that? I object to that, Your Honor. Yeah, I think so, Mr. Franks. You want to bring somebody in to give testimony that's going to be inculpatory of Mr. Perez, and I think that any motive she may have, whether it has to do with whether she committed theft or whether she was mad because he called the police, I don't think it's appropriate to shield the jury from having knowledge that there was a potential area of animosity, and that's the only reason why I see it. I mean, other than that, the fact that there was no lawsuit filed, and that's it. I mean, Mr. Allen, I wouldn't allow it to come in for an unfiled lawsuit, criminal lawsuit with the filing of a lawsuit. I wouldn't allow that to come in, so I'm only going to allow you to approach it from that perspective. Not that she stole something, but that he accused her of stealing. All right, now for some Q&A practice. And we will start with defense attorney. Ready? Here we go. How long was that? About a year. And why did you leave that job? I got a call from the crime lab. They had an opening and wanted to know if I was interested, and I was. Okay, I had applied for a job at the same time as Abbott, but didn't hear back from them. Okay, so you at some point decided to change from being a researcher to being an actual forensic scientist, right? Okay, and so in essence with your field response kind of duties, but you are sort of like those guys on CSI who come to the scene and look for evidence, right? Yeah, those guys are portraying some of what I do. Some of what you do, yes. You are the guy that goes there and finds whatever, right? Okay, now I do want to ask about a couple of things though. Apparently your forensic science career got interrupted when you went to Texas for a period of time, right? You went from the crime lab to MD Anderson, which is a world-renowned cancer treatment and research facility, yes, and you kind of got back into that field for a short while, yes. Why is that? You just didn't like the forensics field? No, I had got engaged to a woman who dearly wanted to move to Texas, and I went along with that. I see. The MD Anderson job was the first job I could get that I was qualified for down there. Sure. The crime lab job then came about 3 months thereafter, and you are talking about the Texas crime lab, and you were there for about, not quite a year, 10 months or something, right? And then you moved back to Michigan, yes, or to Madison, or where? To Madison. Okay, and that's when you got your current job with the crime lab in the Madison unit, yes. Okay, now during that period of time when you have been a forensic scientist, did you have training in how to go to a scene, properly collect, mark, preserve evidence? We had on-the-job training in Texas, all right. I attended scenes in Texas. When I got back to Madison, I began attending scenes. I went through the state crime lab's evidence technician school, where the fleet put on a school to train law enforcement officers how to collect evidence at the scene, properly process the scene, collect the evidence, and then let them know what we're interested in as far as getting it back to its how to properly package it and seal it. So would it be fair to say then that you view yourself and your employer, the Michigan Crime Lab, view yourself as a highly skilled Competent evidence collector at the scene? Yes. All right. One of the things I noticed on your qualifications, a course you took was called Courtroom Testimony Techniques. Yes. And that's where you are taught how to properly present yourself, right? Yes. How to look at the jury when you are giving answers? Yes. I'm not saying anything is wrong with that. It's just specialized. That's training that you get as part of your job, right? Coming to court is part of my job. I have had training at that, on that. And we will stop there. That will conclude our Q&A practice.